preparing to start. If everybody would please mute your line, because we're going to record this so others can do it later. So it's the best quality we can. Okay, again, we have a lot to cover, so I'm going to go ahead and get started. If you attended the presentation this morning, or then you know some of the substance about FEMA's Individuals and Households program. This is going to focus more on what do you do when you have accepted a case, and tie in concepts you would already think of on any legal case you accept, but focus on those FEMA matters. They're figuring out the technical stuff for the first time here. All right, so initial considerations. I think is really important when we are first taking these cases, and so I'm talking about that a little bit. We figure out the client's goals, let us know what to expect, identify and manage the deadlines, and we're going to talk to the client about forms and documents and other information we're going to need. So I'll have more detail on each of these. So there's the empathy. When other legal matters, it's time to get back to us, and then they don't, and so we close it out. And we do have to manage the volume we're dealing with here, but here, if clients are not available by phone because they're running out of minutes, or the number's not working, they've been around and we just can't get a hold of them, there will come a point we're going to just have to close out what we're doing. You know, we have to keep deadlines and that in mind, but we need to try really to keep with them and reestablish contact, because their lives have been upended recently. They are displaced, and so they may be moving from place to place, and their phones may not be on consistently. And so we're instructing our intake workers to try to gather as much contact information as they can, message phone numbers, email addresses. So you always want to serve our clients well, but under these circumstances, you know, please be as aggressive as possible in trying to actually reestablish that contact and work with them. And then keep in mind, many are already frustrated with the various bureaucracies that they're having to deal with to try to get recovery going. And so we want to try to eliminate whatever bureaucratic elements we can in dealing with us. They may have contacted an intake worker, and then they're contacting, you know, a paralegal and a lawyer, and we need to just try to explain what that process is and try to reduce some of that frustration. Communication may help improve that. And then watch out for disaster fatigue on your part. I'm picking up the definition of it here, throwing it as secondary kind of trauma, but a gradual lessening of compassion. I mean, we've been hearing about Harvey for the last 2 months, and then these other disasters on top of that, and just we've all lots of these stories, but for individuals we're working with, I mean, they're living it in a way at least most of us at really have not had to deal with, and so just try to be mindful of that as you're working with them. And generally, every advocate I'm working with, that is what's happening, but just something to keep in mind, especially if you're working on cases remotely. Try to really think about what your client's situation is right now. Okay, their goals and expectations. We would always be thinking about this when we're considering taking any case. And just like with any case, we do not rely on our client to spot all of the issues. So when you first are taking a case and you see the way it's been described by an intake worker, please understand that is a version of what the client articulated to be their problem. It's still on you as the advocate to evaluate the big picture. What are the client's needs? So one of the attachments for this presentation is a FEMA HP category list, kind of a 2-page outline. And so I would suggest, you know, you have that handy as you talk with the client and interview them further to make sure you're understanding what's going on in their situation, and write down, know about their needs for each of those categories and whether FEMA has already made any decisions on those categories. Now, I'll item and explain what details you need to be focusing in on as far as what decisions have been made, but that 2-page tool will help you with the universe of what we're looking at with FEMA IHP, so what clients' needs and decisions already made. If on you as an advocate to educate the client about the FEMA IHP program. Some of you are learning about it for the first time, so this may sound daunting, and I hope that the training earlier and some of the materials and that available to you are going to help you do this, but clients are just learning about it for the first time usually also, and they're getting in piecemeal and probably confused, and so we want to try to explain to them to some extent the house assistance program versus the other needs assistance program, and which is administered by FEMA versus the state. Some clients are confused because they get a check from the state. I didn't apply with the state. Why did that happen? And if you understand about how the FEMA IHP program works, like from the webinar I did a couple hours ago, that can help you explain these things to the client pretty quickly. Just, even a 2 or 3 minute over these different things to help figure out what your needs are. This is also your chance to adjust expectations on eligibility, saying, well, I really want FEMA to help pay for my deductible based on what we know from FEMA policy statements. That's not going to happen. So you're going to explore, they have good arguments to work with here. And sometimes they may decide, well, if that's the case, I don't want to appeal, or you may find other they still are going to work on with them. They're saying, I want in my house replaced by the disaster, and I had really nice furniture. No, this isn't insurance, essential needs, serious items, function stuff, what you might get replaced. Replaced. Then you letting them know what they can expect. And timing. We are going to submit all of our appeals timely. That means by deadline. And they'd be thinking, are you going to file this for me tomorrow? Or file this for me next week? You don't understand. I'm sleeping in my car. I mean, we have to balance expediency with doing something we think is likely to succeed or puts them in the best position of getting help. And so explaining to them what process is going on there often helps them understand, okay, this may take a few weeks, but I don't want to and then get a denial either. Find out, do they have anything they need to amend or correct on their application? Sometimes they'll tell you, when the inspector was here, you see this because this part of the ceiling fell down later. Okay, well, we need to tell FEMA that. And if they have not received any decision at all on other needs assistance, or there's a few specific forms, but if heard anything at all, that's a red flag. They need to apply for the Small Business Administration disaster loans. They need to do that before that deadline, which is coming up. I think it's November 24th. At this point, they need to apply for that, and so that interview with them, trying to take stock of what their needs are, is your chance to prompt them to apply for that loan. And then there may be other benefits at any point in time that they should seek. For instance, the Red Cross benefits are available through October 10th. We were making sure clients knew, go apply for that before you miss your chance. And I'm telling clients now, if they were denied those benefits by Red Cross, then if already appealed, then we can help them try to check status on the appeal. All right, so you also have to tell the client what do you need from them. And I like to confirm this with a letter, or if I'm meeting with them in person and we're trying to do all this pretty quick, I may handwrite a list of the 4 things I need them to bring back to me and the date that I want them to bring it back. But that helps y'all literally on the same page about what's necessary, because these deadlines do run fast. And as far as what additional information and documents, I'll have some slides on that toward the end that pertain to certain kinds of denials. Up front, I'm explaining to the client the need for ongoing contact. Yes, they may be displaced and moving from place to place. They may be in a hotel one week and then staying with a friend in another city the following week. As long as they keep updated on how to reach them, you can still make this work. But if we lose track of them and the deadline's approaching, we might be able to help them appeal. With that, I like to do an appeal when the client comes in to sign the documents that have to go along with the appeal. I absolutely take these cases with the mindset I'm going to do this appeal for them, but they do have to in there to get back to sign the paperwork, bring in what at least minimal support documents we need for their particular bill. And that's when I am kind of stepping up the service I've agreed to provide from investigation to appeal. You don't want to say you're going to appeal something for someone and then they don't call you back and you're not in a position to actually submit anything to FEMA. So keep that in mind. And then the clients need to sign declarations under oath to accompany the appeals. You're not declaring under oath whatever the facts are in their case. You're their advocate. They're making their own statement. Their policies says that the appeals should say at the bottom, I did under penalty of perjury, the foregoing facts are true and correct. So if your client is being a pro se appeal, they could certainly just add that to the end. We have decided that it makes the most sense to us that we write a cover letter explaining the argument, what the supporting documents, say of the issue, and tie in the client's declaration. But we have a separate statement containing the facts that is actually declaring, and then have them sign that. So that's just always an exhibit. At this point in the call, let me ask if everyone will please mute your lines unless you have a specific question at the end. Just so wording is as good a quality as possible for people who are going to listen to it later. And I've said this in the other presentation also, but it's such a big point right now. If they're saying they haven't heard anything, I want to tell them, well, let us know you hear from FEMA. You're waiting on a decision. Because there are some reasons that they may have heard anything and must take action now. Best you hope for is they actually are just waiting on a FEMA inspection. But if you check, you might miss an opportunity to catch some problems. So checking the status, you can do that through the FEMA helpline. You can request a copy of the FEMA file. FEMA disaster recovery centers are open in a lot of our communities, and they are still open right now. My guess is at least some will be operating through December. Or can go there and request that copies of their FEMA letters even be printed. I don't know that that's always the case at DRCs, but for this disaster, they have been working with people to do that. And then people who have set up their electronic account for their FEMA registration can check engine there. And fear is if we do not help them check the status, they may have missed electronic notices. If they applied with FEMA and set up an account to check of their application online, they could choose to at some point receive communications by mail or electronically. And if those are being sent to them, they're just missing them. They're denied on September 3rd. Their deadline is like November 2nd. It doesn't matter that they got it electronically. They're charged with that knowledge. And so we want to encourage clients to check that information, and some I need our help to get in there. I think some of our clients signed up online because they were having trouble getting through to FEMA on the phone. They were computer savvy. They set up electronic access and electronic notices without really understanding what that was going to require of them. And so we're able to help them change their communication preference to be by mail for the future correspondence, and then you're able to even print off those or download them. So then looking at the complete overview of what decisions have been made and what information has been provided to them by FEMA. You also may find that there's an error. We've had some clients where they found their address had been typed in wrong. It might have been a typo they made themselves when they were adding information online, or the alternative for people to apply is by phone, where you're saying things to a FEMA employee who keys them in. So if they make a typo in your address, you might not be getting the letters. After your client, and this is the upfront interview once you have decided to take this case, you want to know what has their communication with FEMA consisted of so far. Certain application, and so they generally, when FEMA acknowledges receipt of someone's application for assistance, they send a letter that's fairly lengthy with different paragraphs about resources and programs that are available, as well as a printout of the client's application and the fields that are populated by whatever the FEMA employee typed in during an application or what client entered into the computer on an online application. They should review that application carefully carefully. They answer questions right. We've had a client who responded to a question about whether they had insurance and said yes, and that affects her FEMA application, but meant she had auto insurance, and they were looking at buying her housing assistance because they understood her answer. So look at the application to see if that's what the client believes to be true. Find out from the client, had they had a FEMA inspection done, and with the FEMA inspector, communication occurred during that appointment. Communication has happened by phone or in person at a FEMA Disaster Recovery Center, now that these are open in many of our communities and have been open for weeks. A lot of the working with, in fact, with us by finding us inside the FEMA Disaster Recovery Center. We staff disaster legal services tables there. We're about to end our presence in those sites, but we have been in those sites for many weeks now. And so these are those who are aggressive enough in trying to assert their rights and help with recovery that they're visiting these disaster recovery centers. So if they talk to us there, they probably talk to FEMA there, and some of our clients visit these sites pretty frequently. They're wanting to take action and toward recovery, so this is a place they are able to try to do that. And then find out what has happened in writing, what have received from FEMA by mail or electronically, and what has been sent to FEMA. Want to see what appeals clients may have submitted on their own, or what documents they submitted to supplement requests for help. And if the client has nothing else, I've had some clients who say, I got so mad I just threw everything away. Okay. They have nothing else. You need that FEMA registration number. That's the key to getting information. We've had a couple of clients who didn't have that, and we've got to try to figure things out then, but it's more difficult. All right, so you want to get that FEMA correspondence and review it really closely. Ask for Small Business Administration loan document. Well, most of the clients are just bringing in a letter saying they were denied the assistance, and that's what we need to know. Others may have information to review on that front. Now, the most important parts of the FEMA correspondence for me as a are codes for each award and each denial. And so that two-page FEMA carries document I mentioned, I want to copy onto there whatever codes pertaining to those different categories of assistance, and the award amount, if there's money award, or each denial. I want those codes. And then take note of correspondence that's requested supplemental information. What I'm seeing for this disaster is FEMA is giving people 21 days to supplement with certain information. So instead of an outright denial on transportation assistance, they may tell people, we need you to provide this information showing you, in fact, had your vehicle insured during the required period of time, or you child care needs that related to the disaster, and they're giving them 21 days to respond. If they miss that deadline, they can try to submit the documents, but it's already been denied. It might be an appeal instead of a supplement of the information. Also, this has come a number of times, so the dates are huge. We want to make sure we are aware of the deadline, so the dates on these letters, that's also on my two-page FEMA IHP category list, my overview of what's going on in the case, and pay for the fact that the letters that are in Spanish for our Spanish-speaking clients, the dates are appearing with the Spanish convention, where the day of the month appears before the month. And every once in a while, that really scares us because we think there's some deadlines off there, and then we realize, oh, it's flipped around, and it's just fine. But watch out for that. Always, if your client has already appealed, this happens often. And the reason for that is kind of the clients are in crisis. They needed help yesterday, and they are doing what they can do to make that happen. And as a related matter, FEMA's messaging favors expediency. However, well-intentioned, the messaging to indicate that the appeals are easier than, in my opinion, that they actually are. So our approach is to try to favor quality over treating it as urgent. They're urgent, and these deadlines come up fast. You have 60 days from the date of most of these decisions to get it done. Timely, in my means, meet that deadline and use the time you have to improve their chance of success. And I think it's a matter of when you are first connecting with your client, you make sure that they understand that is our strategy. We're going to do this timely, but you work with me so that we are trying to get you the best product, best appeal we can for your deadline. And so guys are already cases that are, you have 4 days. It's relative. We're going to do the very best we can with the time we have, but it's not maybe the same appeal that you would have been able to do if you'd had 6 weeks to do it. And that's just the reality with these cases. If there are 800,000 plus people who applied for FEMA help after Harvey, the inspection started, a day or 2 or 3 after Harvey, and a lot of inspections getting done every day. So we have many clients who were denied on August 30th, August 31st, September 2nd, and it's just a rolling thing. And every single one that has a denial on that date, the deadline 60 days out. So we've got a lot of different people who need help all at the same time with similar issues. We're just going to jam. So if your client says, well, I did actually appeal on my own, I hadn't heard back from you guys for a few days, and I decided to just write, or the FEMA person at the DRC told me this is what I should write, because it happens. And also that's out there for this disaster, there's a FEMA disaster case management program. Caregivers who are providing some holistic services and great for all kinds of social service referrals, but they've also been trained to fill out templates, fill in the blank FEMA appeal templates. And I don't think the appeals that they're doing are what we are doing. On the other hand, it is getting an appeal into FEMA. And so if a client has already appealed, let's say they went and were at a disaster recovery center asking for help on a Saturday when we did not have staff at the legal services table, they've basically received help from disaster case management workers to submit an appeal on the spot. So if the client has submitted an appeal one way or the other, you are they content that? If they are, we will close out our file. We don't need to do anything. It's the client's decision, how they want to proceed. And then we give them the disaster hotline number in case they want to reapply later. We hope their appeal is successful. If it's not, they can contact us and we'll reevaluate them. It fails, but they still want little help, especially when we explain kind of our approach and how it may differ from the other approach, then we can view what was submitted and supplement it. And it's taking FEMA about 90 days, they have 90 days to respond. We don't know yet how quickly decisions are going to be made. I would expect for this event, because so many appeals are in the pipeline, it is likely to be around the 90-day mark for these appeals. Now, maybe some categories that get decided faster. And I would think we'd have some time to supplement borrowed time when we're in that mode instead of appealing before a deadline. But we have to figure out how to prioritize all the different cases, but supplement when you can. And if your client has appealed on their own or worked with disaster case management folks to appeal on their own, you need to figure out a plan for communication with FEMA. We don't want too many cooks in the kitchen, so if your client is going back to the disaster recovery center every day and talking to this FEMA worker and that FEMA worker and checking the status of the appeal you submitted and more documents because the FEMA worker suggested that might be helpful, it's going to mess. You're trying to figure out what's going on. And I would suggest if you're handling the appeal, talk to the client about, work with me, and I'm going to help you control the presentation of it. We're going to do one really good appeal and get everything in together, or if we think we need to supplement, we'll figure out how to do it and fit in. I give clients a copy of everything I submitted. I want them on the same page with me, but try to off the things have been said at different times, and it just gets really confusing. Deadlines. You have 60 calendar days to appeal from the date of a decision the client disagrees with. And I've run into this a few times, so it seems obvious, but we may have to kind of check ourselves. Some of the little tools, the count deadlines when we're working on cases in state court or such. do not use those to count the 60 days because it doesn't matter if the deadline falls on a Saturday, that's your deadline. I would suggest when you calculate these out, if the deadline falls on a weekend and you're not really going to submit it on a weekend, you make sure you get in during a week for that. Can appeal late if there's good cause. We don't want that happening on our watch, of course, but if a client is coming to us after a deadline and we have the capacity to assist with it, we can explain why we would like FEMA to consider it then and give it a shot. And we have seen that work before. And I mentioned earlier the 21 days to provide supplemental information. I'm seeing clients miss that deadline left and right. They come to us and they've missed that deadline 2 weeks ago. If they've been denied already as a result, okay, you can deal with it in an appeal. If they haven't been denied yet, then they could go ahead and supplement sooner rather than later. Extensions, I've not ever been able to request one and get confirmation in writing that I would receive an extension. It's not like a motion for continuance we would file in state court or something. But I would recommend when this comes up, you file something timely and include in there a request for additional time to supplement it. So we've had this come up with bills where someone has been denied because they have insurance. A deadline is on us. So you send in a letter and we are appealing FEMA. There is some insurance coverage, but it will not meet all of their needs. We believe they are going to be eligible for FEMA assistance. We're still waiting on the insurance company, so we want more time to supplement, and we will fill you in as soon as we hear back from the insurance company. I haven't really seen this kind of thing accommodated, even if they don't send you a letter saying we will grant you more time. But in those circumstances, think about it, that's probably the best you can do. But don't ever pass the deadline and then say good cause for doing it late. Always try to get it in early. How many appeals are allowed? Under federal regs, you get one at the apple on housing assistance categories. I like to discourage anyone because for every past disaster we've worked on, more bites work. You can do more than one housing appeal on, and this is true for the different categories of assistance. So if you're appealing rental assistance on one issue and home repair on one issue, looked at 3. And at some point you may see a letter that says this decision is final. And a few of those for Harvey already. It's pretty early to be seeing that, but we are. Mike is, depending on the circumstances, I might appeal again anyway and explain why there's good cause for another one to be considered. My worry is clients who may be, in trying to be aggressive and asserting rights or trying to put their own recovery, they may appeal 3 times already and don't know what to submit, and they're just writing letters left and right because that's what the old might work. Tell us why you disagree, you know, FEMA. And then they end up all their appeals. They're able to get involved now and say, you know, they didn't know exactly what to submit. Please consider this and have everything you need to look at FEMA and get their best chance. I would, you know, recommend we do try to help people with that. All of the housing assistance stuff is just written advocacy. The other needs assistance. This is the part that the state of Texas administers, the Texas Health and Human Services Commission. We have some different types of considerations here because the Texas Administrative Code controls this. So there are initially 60 days to request reconsideration. We'll call it an appeal or requesting reconsideration, same difference, they're going to look at it. We submit these to FEMA, same FEMA registration number, and the federal folks are supposed to forward it over to the state entity. I don't know if it's that way, but it does. Consider appealing housing assistance needs in one letter and other needs assistance issued in a separate letter, and make really clear at the top of that other needs assistance letter, please forward this to the Texas Health and Human Services Commission. You don't have to do that. They should forward it anyway, but I have had situations in the past where we call to check the status of both appeals, and the state has not seen the other needs assistance appeal. And it just slipped through the cracks. The folks at the federal processing side didn't forward the part that the state needed to consider. In any event, 60 that initial appeal, And then if you're happy with the outcome of that, you can again. But that is different. This is where you can have the most formal appeal proceeding in this entire process. They have an other needs assistance that's been denied for a second time, or maybe a different outcome. Maybe they were awarded the assistance that second time, but they want to appeal again because they don't like the amount. And you can request a telephonic hearing, and the fair hearing rules that apply under the, like we would Texas Medicaid hearings, they apply here. And you can request the file and the basis for the underlying decision, and there's more materials there than we do FEMA files from the national site. The hearing officer's decision is supposed to be final, but concerned about the procedural accuracy, you have 30 days to request an administrative review. And they can reopen the appeal. There also is a reference to judicial review. We have done that, but that's something if your client is satisfied and you think that there is some grounds to move forward or want to consider it, there might be that option. That is not true for housing assistance. If you represented on an appeal already and the client's still dissatisfied, do you appeal again? Consider is, do we have something new to put out there, because otherwise, would it make a difference? I think FEMA misunderstood a fact or misapplied the law or policy. We've had that happen, and I'll say, even though a decision was purportedly final, I've appealed, and it's been clear on the face of the FEMA file that the FEMA decision maker was looking at the wrong set of facts. They included fact statements about my client's file that were simply not accurate. They may have confused with someone else. They would not consider another appeal. And I'm not sure what to do about that when that happens, other than, you try that appeal and write your letter. But and then there's a lack of clear standards in general with FEMA, and so that does tend to encourage more appeals. You don't have new information or documents to provide, even if I'm told that it's fine. If I think there's something wrong, we go ahead and do that. But we have to balance that with our limited resources too. So do your best judgment as you're working with the client. Okay, at what point do we have direct contact with FEMA about this case? The important thing to get there is signature on the FEMA authorization form, and that's another attachment I've included for this presentation. Your fax or mail that to FEMA, that form, along with a copy of the client's driver's license or photo ID. If they don't have that, then we'll have to kind of troubleshoot it a different way. But I tend to send FEMA that form so that they know they're going to be able to talk to me as soon as they get that uploaded. For disasters, it might take like 4 or 5 days. I don't know for Harvey how long that's taking, but the system is so overwhelmed, they very well making a longer time to get those uploaded. But I request a copy of the client's file be mailed to me at the same time, just to knock it all out with one letter. And then while you're waiting on FEMA to upload that form that your client signed saying FEMA can talk to you directly, the only way FEMA is going to talk to you about the client's file is if your client is with you. So be, physically or all in person at the Disaster Recovery Center, or it could be a phone, a 3-way phone call. That's going to take your client through certain information to confirm that they are who they say they are and that they should talk to them about the file, and then your client can give permission for them to speak to you directly. When you do FEMA, and here I'm focusing on the housing assistance part that the federal government's going to deal with, the number, 1-800-621-3362, that's the same number that people use to apply FEMA. You can get information through the automated system with your client's permission to use their identifying information. And then you need to ask questions of a FEMA helpline operator, have that authorization form your client signed, and the last 4 digits of the client's social security number handy, because that's information you're going to be asked in order to confirm that you are the person who's authorized to speak on behalf of your client. And keep in mind this is different perhaps than some other advocacy with administrative agencies. FEMA doesn't have a particular decision maker assigned to your client's case that you're going to be able to communicate with. Calling their helpline and you get who you get. have a call. And what they're doing is reviewing the notes in the file that they're able to pull up on the computer. Some basically will read stuff to you, and some of them are giving you their spin on it. And sometimes they're right, and sometimes they're wrong. And you need to check on other needs assistance matters. There's a different phone number for that because it's the state agency making those decisions. And I've found with these folks, there's fewer staff case handlers involved, so they may call you after you submit an appeal. And here actually be talking to a decision maker, so it's just a kind of thing. They seem a little less formal. You can also have contact with FEMA at the Disaster Recovery Center, and it's similar to what you're going to experience at the helpline. You're speaking to a FEMA employee who's not got any particular responsibility for your client's case, and if you're asking them questions about your client's case, they're reviewing the notes in the file that they're able to access. You also need to change at the Disaster Recovery Center. The federal government deals with the housing issues and the state deals with the other needs assistance issues. The FEMA staff at the DRC, they run the housing assistance program. And their messaging, they tend to tell clients, oh no, I can't answer any questions about your personal property. That's the state. And the client's thinking that you're FEMA, and I applied with FEMA for all this stuff. Sometimes at the DRCs, the other needs assistance program folks are there, the state is there, but again, just like you call a different number, you would have to walk to a different table to get information about the other needs assistance issues. And there are some parts of it that the FEMA employees can tell you about other needs assistance, but it's just us. So understanding how those different programs together may help you as you're seeking information and may help you explain it to your client so they're less frustrated. All right, so if you send a file request, when can you expect FEMA to send you the file? See them as fast as 1 week after requests in past disasters. Don't count on getting them before you're doing your appeals. I don't know how long it's going to take them, but you know, with 800,000 plus from FEMA, 2 million plus after and more from Maria. There's so many different things going through FEMA's system, so I don't think we're going to get our file request processed quickly. And if you need certain details for your appeal, again, call the helpline or talk to a FEMA worker at a disaster recovery center to see what details they may be able to provide you. For your clients wondering why they received $735.22 for home repair assistance, by calling the FEMA helpline, you can get a breakdown, you know, how much of that was for sheetrock and how much of that was for shingles and so on. And then calling the helpline or speaking to FEMA at the Recovery Center, you may be able to glean some insight about the decisions made so far if they are able to relay to you comments that were by the inspector or decision makers earlier. The discussors, there will not be comments early on for the most part because over 90% of these cases are decided by computer formulas that are reading the different information that's been uploaded. The application and the inspection findings are kind of put into the system, and then it prompts the of letters that have award or denial codes. On appeal, things are decided manually, and so after appeals, the FEMA files have more of that insight in there. The appeal will explain a bit about why they either agreed with the appeal or why they're still going on it. And so that's helpful, especially for subsequent appeals. But the inspector comments could be there up front. Inspector comments are generally not required, or at least that's been true past disasters, but they do choose to include them. And then get ready for alphabet soup. And I need help interpreting comments, let me know, or let any of the other folks that have some experience on these cases, because there's a lot of acronyms and different kind of conventions and how they write those. This is for some of the administrative advocacy that we do other agencies, but FEMA may send you the file and you request it, and they send it to you directly. They will not send you decision letters, so you may submit appeal and have the FEMA authorization form, which states that you're advocating for your client and FEMA is authorized to release information to you. Will still send the decision letter to your client. So my clients know that, and that they relate to you anytime they hear from FEMA, whether it's verbal or written, because if they get another letter and they want to appeal further and they don't tell you, could miss your deadline. And sometimes the clients think, well, you sent in the appeal, so I thought FEMA would send it to you. I just thought I got a copy. That you, or explain to them how this works. It helps if you've sent in a file request to call FEMA. I mean, I would wait about a week. I mean, you can wait a little bit longer depending what your timeline is like. But it helps to check in just to make sure it's been received and that it's being processed, because things can slip through the cracks, and so you calling may prompt them to request over to the mailroom or whoever's going to process that request. Occasionally, we find out that there's been some processing problem. Sometimes people will call us from FEMA and say, hey, the authorization form is signed, but the client's place of birth, this one blank, is not filled in, so we're not going to process this. Do you want to resend it? But they don't always call and tell us things like that. Sometimes we'll call and check the status, and we'll be told there was a problem, that we didn't fill something out. Make sure you have it in front of you, because sometimes we'll say, nope, I'm looking at it right here, and it was just fine. And then they will realize that and push forward within their system. But sometimes you even have to advocate for the fact that you actually did submit it properly, and to see that with you on the phone before they push it forward. When you do get the FEMA file, you will find it includes copies of the correspondence, whatever FEMA has sent to the client and whatever has been received from the client. And really helpful, especially very much has gone on, because a lot of our clients, depending when they're coming to us, they aren't able to provide us with a comprehensive overview of what has exchanged with FEMA so far. So when you get the file, you know you're looking at what's gone back and forth. And the comments I mentioned, you could get inspector comments or decision maker comments. Sometimes it does have breakdowns of the amounts awarded. You can also call FEMA to get that, but it's not included in decision letters generally. That's for the other needs assistance stuff too. Why did they get, $22.15 for personal property? At times we're able to see in these comments that FEMA is considering demanding that our client pay funds. And so we may be able to try to head that off. You just find these different things in the comments that are helpful. There's a record of contact between the client and FEMA. Whenever you call FEMA to talk to them about the case, there's a record made of that, so you can have your own conversations. And third parties. So you're going to call contractors who did estimates generally, so you'll see what happened there. The inspection report you're sent is pretty skeletal. It is not as detailed as what the inspector is actually providing to FEMA electronically. And I mean, that's just the way it is. You don't even get the breakdown of the amounts that were for sheetrock and the amounts that were being paid for shingles there. You can get that from the helpline, because I think they're reading it from something electronic that's in front of them, but it's not part of our printout. The photos that your clients are probably telling you that FEMA inspectors took at their house, at least they didn't used to be required to take photographs. We hear they do sometimes. I know they decide what components of the home to depict in photographs, but we don't get copies of those pictures when we get these FEMA files either. Now, when you're putting together your appeal packet, you need to have your cover letter, FEMA authorization form, and client's photo ID or driver's license, and whatever supporting documents pertain to the decision you're actually appealing. And then you need the client's declaration, and the decision is generally like a one-page or two-page statement, whatever is necessary to address the facts at issue in your appeal. But it needs to have that language at the bottom. I declare under penalty of perjury that the foregoing is true and correct, and your client needs to sign that. And then I didn't put this in the application itself, but you do not have to send FEMA the original. So a lot of you guys are working on these remotely. If your client is signing it and then it's getting emailed and scanned back to you somehow or faxed or whatever, that's fine. You can submit that. But you have to get their signature on this stuff. If you don't have time, at least get your appeal submitted timely and then submit as quickly thereafter as you can with the client's declaration, if that's an issue. Appeals, I'm just going to go through a few of them that are making up the bulk of the ones we're dealing now. A lot of clients are being told their home is actually safe to occupy, and they would beg to differ. Or they have received home repair, but it's too low. We're seeing people who have been told they failed to verify ownership, that they have no personal property needs, or that similar language for other types of other needs assistance, medical or dental or transportation. They may have been denied because they have insurance, or we've got the shared household issues. So I'm going to use the remaining time to talk about what kinds of documents we gather for these types of appeals. Background on this is these FEMA inspectors are fact finders for FEMA. They're FEMA's eyes and ears in the field. So they're this whether ownership has been verified. The client is putting together their documentation that they think supports their argument. At least the initial decision is going to be made at the client's home when the FEMA inspector's there. The client has some usual facts, expect going to be denied, and it's going to be addressed on appeal. The good news on appeal, that's something that can get decided by the FEMA decision maker and addressed right away without the inspector having to revisit that issue. Inspectors look at whether or not the applicant occupies the home. So, the driver's license with the correct address or a utility bill, they can try to get off that problem by having that available for the inspector, but the inspector one who's checking off that box or not. Decides whether the damage or losses are disaster related. Whether housing damage affects the habitability of the home, is it unsafe, unsanitary, or not functional. Whether essential items were affected when you're talking about the other needs assistance, and whether our needs are serious. So a lot of discretion and how to actually apply FEMA standards to the client's facts is resting with this FEMA inspector. You should know FEMA works with two companies to provide inspectors. These inspectors are generally not FEMA employees. With the RV applications, and Irma applications, and Maria applications right now, I can imagine how many different inspectors are brand new to this, and how quickly they've been trained. The qualification is simply they pass a criminal background check. They do not have to have any construction experience whatsoever. Some do. Some people that are actually visiting clients' homes work FEMA and have worked there for 30 years. But there's a whole lot of them where that is not the case. And each one has the same authority to plug information into that client's file and have FEMA make decisions about eligibility. Now, these inspectors are not to get on ladders, so I think that makes it harder for them to evaluate the damage to roofs, but as a safety issue, that's the policy. And they are not going under homes. So if you have clients who have like a pier and beam home and it's shifted because of flooding, they're not having these inspectors go into the homes to check that out or get plumbing under the home or different things like that. There's a high volume, and in order to try to quickly get aid out to people, they're doing these inspections quickly. We want them to move efficiently, but there's also some quotas that they'd be rewarded for hitting. And so sometimes clients tell us about drive-by inspections or the inspector seemed rushed. That is part of this big picture that very well maybe went into that client's home to take face value. Okay, so somebody has received a decision saying their home is safe to occupy, or they received home repair but it's not that much. It's critical for these appeals that they get contractor estimates, at least of some kind. And then the client has to do their fact statement. We need these declarations for all these, but we want their take on what damage they sustained and how it affects habitability. If they have statements from the local government, we see this once in a while. It's not something you necessarily can go drum up. It's just if happened in a particular client's case, great. Or if your client had their pick in the newspaper because of the condition of their home, those kinds of exhibits are helpful. And then I recommend that clients take photos. If they have before photos, great. And I think that just helps, FEMA decision worker see what's going on. They're reading these things over and over about different elements of the home and how much is damaged. And the inspector says this versus the inspector, but seeing the hole in the roof, seeing the mold, seeing the cracks in the wall, I think can be pretty compelling and they're going to look more closely at the different other supporting documents that are there. But I don't want any client to be discouraged from appealing if they don't have pictures, because FEMA's even told us those aren't considered. We hear conflicting things on that, but we've been told the decision makers are one office and they may not have seen the pictures that were actually in at the mailroom. So that's frustrating, but just I don't want clients to stress if they don't have the photos. Estimates are basically your way of just the inspector's results were with your own expert. FEMA's trying to decide whether to second guess their inspector. If they agree that something's off, they just send another inspector. They don't give your client whatever the contractor said it's going to take. They just send their own inspector to apply FEMA standards. And if they don't even think you give enough to have them question the original inspector's results, it's just enough. There's not necessarily a second inspection. Estimates need to be itemized, not just a lump sum for everything, and verifiable, because FEMA will call these contractors, particularly if they did not include a statement on causation. We want to find out from the contractor who is saying it's going to take $17,000 to do all this in the client's house. Did you actually go there? And did you have any pre-existing damage? Oh, really? Where? How much? Okay, well, was there other disaster damage? And they ask about a whole series of questions. So your clients need to know, too, that these contractors, they better call FEMA back, or that may cost them an inspection. They need to work with cooperative contractors. That's difficult for the contractors are as limited as they are right now. That's generally been the practice. And if they can't provide the estimates because they're having a hard time getting contractors to their home, appeal and explain why. You know, your clients, it's not from trying that the client's appealing without estimates. And in the past, FEMA has said in some letters they want licensed contractors. I didn't see that in the letters I was looking at this morning. And just be aware, though, in Texas, there's no license for a general contractor, just for special contractors. Basically, use what you have. If your client is bringing you on notebook paper a statement from a contractor, even if it's a lump sum, if that's the best they can come up with, get a deadline, and if they can supplement with a better estimate soon, great. But we're going to try to just help them tell their story and, you know, the best shot they've got. Verify ownership. You know, if they have proof of legal ownership, great, or license fee, great. If they've got a deed showing titles in their name, just have that ready. But where we run into trouble is when it's not straightforward. If they're a life tenant because they're a surviving spouse and they have a homestead interest, but they don't have documentation of that, the inspector's probably not going to buy that. They're going to say, you know, not verified. And then on appeal, we help them explain what provisions of the Texas Constitution or the Estates Code give rights to the client having this right. Or we may have prepared some paperwork that supports that and has been filed with property records. But we can, you know, try to put those different arguments together, seek help from our subject matter experts as necessary. You've got the probate team, you have a colonias and real estates team that can help us analyze those things to see if the client has proof of this. And if neither of those applies, does the client live in the home rent-free, pay property taxes before the disaster there, or for maintenance, like major repairs? And clients do tend to tell you, you know, I just fixed the house 3 months ago, and now, the disaster's messing it up. You know, ding, ding, they're telling you they paid for maintenance before, so do they have any records from that? Or can they get in touch with the person that they paid to do that work so that now they can get an affidavit explaining that, and that might help them get past this ownership hurdle. If they have a contract for deed, great. That should do the trick. If they're paying on it and aren't to get legal title yet because they're still in the process of that, that works. Unfortunately, this really depends on how it's worded. Some of the FEMA stuff says we will not recognize rent-to-own documents. And those executory contracts, there's a TRLA that are going to be better at explaining, you know, how all those things work. And may need to consult them if we've got close calls on these. But I've seen clients who turn in documents that use the rent-to-own be denied. But if it's a contract for deed, it's okay. Proof of payments works too. You know, title's not my name, but actually my sister, you know, is the title, but she will you, I am the one who's paying mortgage. And my name's on the coupon book. That works. acting like the owner, so FEMA would treat them as the owner. And clearing title after the disaster is not necessarily going to work. It really depends on the facts. So if a client inherited an interest in the home for parents before the disaster and has been living there, maybe you're going to get them past the hurdle by showing they paid property taxes. But if that doesn't apply, you may have to actually help them file documents, show what they inherited, and that inheritance passed 5 years before, even though paperwork wasn't there, and they were an owner as of the date of the disaster. I don't have this stated here either, but they don't have to be the sole owner. So it helps. They needed to be the one living at home, but owner works. May have paid off a contract for deed, but the seller never transferred title. You know, if they're able to get that now, a statement that actually it was paid off earlier, all those things help show, you know, I was owner at the time of the disaster. You know, I didn't have the paperwork when the inspector arrived. And then there's been lots of mobile home title clearing for this disaster. I neglected to put that in this slide, but we've had a lot of help from the mobile home team and St. Mary's doing those statements of ownership that have been issued by the state response to the paperwork that's been submitted reflect the transfer was actually at an earlier date, pre-disaster. So that's helping clients show I was the owner, I just didn't have all my documents in order. The party affidavits, we use these when we are having trouble getting other reporting documents on ownership front. If we're saying, well, title's in my dad's name, but I'm the one who lives here in the home on the property, and my name's not on the property tax receipts, but really I give my dad the money, and my dad delivered it to the property tax district. You can try an affidavit from dad confirming, yes, that's exactly what happens, but it needs to be a notarized statement. I don't know why in this context they want that instead of a declaration under penalty of perjury, which seems to be fine for every other purpose, but that's what we were told a couple years ago, so we just do it. Rental assistance, if they've been denied because the letter says they're not willing to relocate, this is usually because the client perhaps really didn't want to relocate, and if so, great, there's no need for an appeal. Other times it's because they didn't understand the question. When the inspector goes out there, if they say, you know, if your home is damaged enough that we are going to give you assistance, we'd like to relocate temporarily until you find another safe place to live, you know, yes. But the inspector says, do you want to relocate? No, it's Christy, my home. I'm not leaving here just because it's happened. And they're denied because they answered no. So if they are willing to relocate, that's a pretty easy appeal. You prepare a declaration to clarify that and sit in, and then hopefully get a check to be able to use that assistance. Personal property assistance, if it's insufficient damage, or now I think they're saying minimal needs, or the award's too low, you need to find out from your client what was damaged and how. You know, my door was damaged. Okay, well, tell me how it was damaged. I had several inches of water inside my house, and it warped the wood on the table, and it soaked into the couch. And okay, that's what we need for the appeal. Why is it so bad? And it was actually caused by the disaster. And if it's appliances, you know, my washer doesn't work anymore because it shorted out with the power surge. It's estimates to know how that's disaster related, and the cost would be helpful. Photos, again, that's not crucial. FEMA may not even care about them, but I think it can be helpful, so I encourage clients to do that. And keep in mind, with all of these losses or damages, they have to be verified. And with personal property especially, clients may dispose of the property, might need to health reasons, but they need to understand if it's not there for FEMA to verify that loss, it's a problem. Let's see. Repairs, I don't have that on the slide, but if they make makeshift repairs, they should be taking pictures before, because if FEMA, you know, if you get another inspector out there and they can't see what is wrong with it and verify the damage, that's going to hinder their ability to get help. These appeals, you're just showing the covers and what it didn't. You show that you think they have FEMA eligible losses the client has the insurance doesn't cover. And will not cover the deductible, so make sure clients know that. I've just got a couple more slides here, so I know some of y'all may have to hop off, but if the rest of y'all can bear with me, I'll be done and I'll try to look at questions quickly. If the insurance is delayed, you can ask for FEMA assistance in the meantime and pay FEMA back later. Any client doing that understands they will have to pay FEMA back later. Here are these insurance cases. You really need to get the policies and the claim documents and look through those so you understand what insurance is covering and not. I have some clients who say, well, the insurance adjuster didn't see this because it happened after. When you call back your insurance adjuster, that's not a good argument for why FEMA should have to pay for it. But then, if FEMA won't pay for, if the insurance won't pay for flood damage because it's a windstorm policy, then maybe FEMA can pay for that if you didn't have your flood insurance. Household issues, I think this is my last here. And the denials, maybe saying duplicate, linked, same address. What you need here is the client declaration explaining the facts, and then depending on what's going on, just what makes sense for supporting documents. It's an argument that, this is a duplex, and yeah, we have this address, but I live in an apartment on the right, and he lives in the apartment on the left. You need to make that clear. Or with the landlord-tenant relationship, where, a parcel of land and there's 4 different mobile homes on it, so there's 4 different households. Now, consider the conflict checks that need to be done here, though. Sometimes we have situations where one household member made an application and then abandons the other and doesn't share the money. That's much harder to deal with. All right, now let me get to questions, and in case I am not going to figure out the technical elements of that, if anybody wants to just jump in and ask a question verbally while I'm trying to figure this out. Yourself.
Okay, Tracy, this
yes.
is Katie Euchre. A quick question. You said you can find out the status, like if the person has already filed an appeal, but then how, if we don't get the file back timely, like, is there another way to see the appeal, what was said?
I try to get that from my client, and they may or may not have it. And they don't have it, I try to kind of just pick, what did you submit? Do you have a copy of the estimate? And then sometimes our employees have made with people that are at the FEMA disaster recovery centers, and they're able to go get things printed out, or the applicant can go do that. And so, we just get sometimes with what may be available. But
this is Raul Noriega. Can you hear me?
yes.
I have 2 comments and a question. The first comment is that I think it was somebody asked me about the procedures for changing title on a manufactured home or a mobile home. So I sent them a fairly lengthy explanation with simple advice letters on how to do it. That's what I normally use in manufactured housing cases. But when they said that, it rang a bell that sometimes the TDCA will insert into the new title the date of sale, which was prior to the time of the disaster, even though you've asked for it afterwards. So I thought that might be helpful. And send it to Austin. If you want it, I can send it to you, and you can look it over, and then you can decide to distribute it or not if you want.
Great.
Comment.
Yeah.
The second comment is that the material that you sent, all the different declarations and forms were in PDF, and so it makes it difficult to edit. So what I've done is I've taken one of those FEMA appeals, entered it into Word, and taken out a lot of facts and put in a lot of blanks. And then I've added two particular citations. One is to the CFR regarding owner-occupied, because it comes up with mobile homes and recreational vehicles a lot. And the other is on habitability. Under the Manufactured Housing Standards Act, there's a legal standard for habitability, and it's a pretty stiff one. If there's open holes or the doors don't work right, then it's not habitable. So when saying it's that they're denying it because it's posh, because it can be because you can occupy it, I think one argument that you can make is, well, maybe so, but under the law, it's inhabitable because of the different things that are wrong with it. So I threw in a paragraph about that. Now, my third question is that I'm new to doing these FEMA appeals, so bear with me. I have a client here that was denied housing assistance, so I'm doing a FEMA appeal on housing assistance, but the client only needs rental. does rental assistance fall under housing assistance, or is that a separate appeal?
It does fall within it, and that's one of the things that's confusing with these. It's because of the FEMA computer formulas. If the home is found safe to occupy, whether an renter or an owner, they could be denied housing assistance altogether. And let's say what it is now, safe to occupy housing assistance, but for an owner, that means they were denied rental. For an owner, that means they were denied rental if wanted it, and home repair. You have to think about your client, you know what I mean, and what their needs are. Yeah.
So the answer to the question is yes, even though they're denied housing assistance and they're being asked for repairs, the appeal can be, well, I wasn't asking for repairs because I rent an apartment and unit and the whole thing's been destroyed and I don't have the money to repair the unit and the whole complex is going to be demolished. That answers the question. In any event, would you please look at the 2 emails I sent you with those 2 forms? Sure. And then you can decide, you and I can edit them or tweak them or whatever and see if you want to distribute them to the rest of the team.
And we do have many Word forms that for TRLA people handling these cases in-house, lots of samples, and we'd be happy to send them in Word. The stuff we were putting on that other link, we have been more careful redacting and putting it out there in PDF. But we definitely will be able to, we want to try to make it easier for people to do this without having to retype everything. But thank you for taking the time to do that on that appeal. And then 2 sites I use a lot, and Evan, you hit on exactly the owner-occupant standard, 44 CFR 206.111. That's for occupancy is the definitions in that section. And then to look at what's the house inhabitable under FEMA standards, 44 CFR 206.117. That's all the housing assistance provisions, and it explains some about rental and repair and home replacement. But that's where they define some of it. I don't think very clearly, but it's what's out there. And then I'm going to respond to a question I was sent here. If the deadline to apply for benefits hasn't run yet, can a client reapply for FEMA assistance instead of or in addition to an appeal? They can do that. That's going to result in a duplicate application or same address, and it could actually hold up getting help. They are better off, dealing with whatever reason they denied assistance head on and appealing that. A new application will not help them. Any comments? Okay. Thank you all for your time and for staying a little bit over. I appreciate your help.